Welcome, everyone. That's the first time I ever got applauded for the first word. Welcome. You've heard that before. Now, if I had given it in like 3 different languages and pronounced them perfectly, maybe I would deserve some applause. But anyway, welcome to tonight's constitutional conversation with a distinguished and very interesting litigator, Peggy Little. For those who don't know our series here, the Constitutional Conversations are an opportunity to talk with a wide variety of people who are engaged with constitutional law in one way or another. Academics, litigators, judges, and historians, and so forth. And to emphasize that it's a conversation, because we believe that the Constitution is something worth studying and really talking about and learning from and discussing with one another. And so I'm particularly happy to introduce tonight's speaker, Peggy Little, who is a graduate of both Yale College and Yale Law School and has had a remarkable career as a litigator. She's litigated just about everything, like mass torts, securities, and she's had her own. I should mention too that she clerked for the Honorable Ralph Winter on the Second Circuit. For those who don't remember him, he was a real giant of the bench, and also one of the founders of the law and economics movement, and so a really important figure. And now she is litigating with a fairly new public interest law firm called the New Civil Liberties Alliance, which was founded by Professor Philip Hamburger from Columbia Law School, and some of you I know. And I'm not sure I have this exactly right. I'm making this up. Peggy can tell me if I get it wrong. But the way I look at it is that they are it's primarily a litigating outfit. And what they do is they bring cases trying to challenge the occasional arbitrariness and oppression that comes about through the bureaucratic state. And you might say, well, can that keep anybody busy? Well, she'll let you know.
Thank you, Mike, and thank you all so much for having me here today. I've really been looking forward to this. The last several years have been an exciting time for testing constraints on administrative power. The Supreme Court has entertained long-neglected doctrines such as non-delegation in the Gundy case in 2018, Article 2 appointments challenges, Lucia in 2018, federal jurisdiction to hear removal, Cochran, in which I was counsel for the plaintiff below in the Fifth Circuit, and Axon, which are companion cases that were just argued a week ago yesterday at the Supreme Court. And most recently, the West Virginia versus EPA case, which insists that major questions must be decided by Congress and not administrative agencies. Or, to put it another way, agencies must operate within their guardrails. Courts are newly willing to find jurisdiction to enforce these constitutional protections that are essential to our liberties, such as the presidential duty to take care. And recently, one circuit court restored jury trial rights denied by the administrative adjudication system at the SEC in a case called Jarkissi, which has received a lot of attention. At the same time, deference doctrines, and I don't even know all the names of those, but we can start with Chevron, Auer, Skidmore, and then if you really want to double defer, you can talk about Brand X. But those deferent doctrines that have long encrusted and denied judicial review of administrative power are slipping away, sometimes in cases without even a mention by the courts or even invocation by the government. So what's going on? For decades, and as recently as a few years ago, successful challenges in the courts of these administrative violations of constitutional rights were unthinkable. I took this job 5 years ago, and my first job was to challenge SEC agency adjudication, and I had 5 solid circuit courts against me. that declined jurisdiction to even entertain any of these Article 2 appointments or removal questions, thus forcing enforcement targets into years-long administrative proceedings before they could ever get to a court that was competent to decide such questions. But by the time the court was considering certiorari in Cochran, which is an SEC case, and Axon, which is an FTC case, that had grown to 6 circuits against us. And even as I speak to you today, we now have 7 circuits against us, and just the lone decision at the 5th Circuit en banc in Cochran. And even when courts exercise jurisdiction over administrative power, a cluster of those deference doctrines has paralyzed the courts in a self-induced state of sclerosis. Chevron, notoriously, has been one of the most cited cases of its time. We even had a case in the 2nd Circuit en banc where the court was fully engaged in Chevron deference without calling it by name at all. You had to really search the record below to figure out that this was a deference case. Now I'm going to take a line from Justice Thomas's questioning a week ago last Monday, which was, how long has this been going on? Americans today are 10 times more likely to face trials in administrative courts than in real courts. For the 2 agencies I'm most familiar with, the SEC wins 90% of its cases in the administrative proceedings, but the FTC outshines them with an embarrassing 100% of its cases over the last 25 years. In real courts, the win rate for the government is about 60%, varies a little bit. In real courts, the prosecution must carry the burden of proof. There are rules of evidence and civil procedure. There are rights to call and confront witnesses, and most due process constitution protections are intact and observed by courts. Now, I've practiced law for, over 40 years now. And when I took this job, I had no idea, zero idea that much administrative adjudication was going on. And so my first question myself when I took this job is, why are we so in the dark about this widespread exercise of judicial power within the executive branch? Again, Justice Thomas asking, how long has this been going on? So let me start with Ray Lucia's case. That was my first assignment, was to write a amicus brief in his case. And it was a landmark decision that really started the court's rethinking of a lot of these questions about administrative adjudication. And I need to stress that Ray Lucia got this case to the Supreme Court because he had the determination and resources to fight. It very nearly broke him. He's broke. He can't practice it in his chosen profession anymore. So I'll tell you a little bit about him. And one thing, if I start to talk about a case like Lucia or Cochran, and I haven't given you the facts, it's because I've been living with them so closely. So just raise your hand, say, facts, ma'am, and I'll give you some. But in Ray's case, it was a ridiculous prosecution. He had used a term in some of his marketing materials, and he was a financial planner for retirement. And the term he used was back test, which is a word that is used widely in the financial planning for retirement industry. It doesn't have a fixed meaning. The SEC has never passed a rule or even guidance or even one of their more vague documents about what they have the power to regulate. And there's a couple very interesting things about the Supreme Court's decision in Lucia. It's a very crisp, short opinion by Justice Kagan, and his administrative law judge was called out by name, Cameron Elliott. Experienced lawyers in this room can tell you that is almost unprecedented. Very, very rarely does a district court judge get called out by name, and almost never, in my experience, is an administrative law judge called out by name. And one of the things that emerged in the Lucia case is that his judge, this Mr. Cameron Elliott, publicly admitted that he always finds in favor of the agency, and he would say that to people in settlement conferences before him. He also told them that if they contested the action, he would impose the maximum penalty. Let me stress to you that a federal judge who made such statements would expose himself to discipline or worse. Mr. Lucia had also called two witnesses in his favor who had been his clients for years and had attended his various seminars and said they'd never been misled or suffered losses. And in fact, no one in Mr. Lucia's case came forward to say they had suffered any losses or damage because of the way he used the word back test. Those two witnesses were slated to testify, and just a couple days before they were to take the stand in the administrative proceeding, they were served by subpoenas by the SEC asking for 5 years of all their financial records from any source whatsoever. That kind of witness intimidation would never be countenanced in a real court of law. So, as you might not be surprised, Mr. Lucia was found guilty of violating the Securities Act, and it was a very disturbing decision from the administrative law judge. What he said is, and this is an almost direct quote, "Under the definition of back test that I have found today, you have violated the securities law." And I hope your ears are sharp enough to pick up the whiff of retroactive lawmaking in that statement. A very disturbing decision. He was fined over $300,000. He was told he could not speak even to his own son in the securities industry, and his registration was pulled for life. Usually, when you appeal an administrative law judge decision, you go to the commission itself. Interestingly, in Mr. Lucia's case, the decision was 3-2, and the two dissenters raised two important problems with his adjudication. First was the retroactive lawmaking by Cameron Elliott, that this new definition he had found that day was a new violation of the securities laws. But also, the commission, interestingly, decided to hear his challenge to the fact that the SEC administrative law judges were not lawfully appointed. And the commission ruled, of course they're lawfully appointed, even though they had not appointed them. And the two dissenters said, well, thank you, the three commissioners in the majority, for sharing your opinion with us, but that question can only be decided by an Article III court. And so Mr. Lucia then progressed to the next stage, which is to go to his Circuit Court of Appeals. And under the securities scheme we're talking about, he could either go to the Ninth Circuit Court of Appeals in the place where he lived, which is San Diego, or go to the D.C. Circuit. At the D.C. Circuit, he split the circuit. Well, he lost in the panel decision and then was awarded rehearing en banc, and that split 5-5. And that the way that works is tie goes to the government or the party who won below. So not until he reached the U.S. Supreme Court did his ALJ get set aside because the SEC had not lawfully appointed him. Now, the articles in the newspapers around that time, and I was trying to get up to speed on his case, reported on a scandal because in a case called Timbervest, which is of no interest other than it was a different case than Mr. Lucia's, the appointments problem was raised, and the SEC actually went into that proceeding and announced, but no, they've always been lawfully appointed. We don't know what you're talking about. Until Mr. Cameron Elliott, who was in the Timbervest case, acknowledged that he had never been appointed. So what you have is years and years of proceedings going on with an appointment problem, and there's no dispute that the SEC judges were not lawfully appointed. Shocking to me. And one of the problems that I want to have you keep in mind on these administrative law proceedings is also the agency has years to investigate you. They can file, civil investigative demands. In Mr. Lucia's case in 2010, they went to him and said, "We don't like your use of the word back test." Immediately, he pulled all the slides from his presentations that used the words. He had published some books that had used that word. He pulled those from distribution and stopped using it because nobody wants to get their regulator angry at them. Nonetheless, he goes through this proceeding in which his judge finds a new definition of a back test as a problem, and the SEC had never once issued a rule that would explain to him why this was a problem. So the other thing that to me is shocking is that in a rational world, if they actually had a problem with the use of back test, the fact that he immediately stopped doing it should end the story, but it didn't. The other problem with the agency adjudication is they investigate people for years and years and years, and then finally when they get around to an order instituting proceedings, because they've got a 5-year statute running, they bring that, and you have anywhere, depending on the size of your case, anywhere from 60 to 90, or perhaps at the outside, 120 days to prepare your defense. Now, recognize that they have been investigating you for years, and they do what we call a document dump. And all of a sudden, in my day, when I started, it would have been boxes of documents. I'm sure today it's some zip drive of documents. But you cannot possibly make it your way through all of those documents in the time you need to prepare your defense. And then, after this hearing, in which you've had very limited time to defend yourself, the agency can and does take years to issue a decision. So you're in this weird limbo where you have a curtailed right to defend yourself, and all of the deadlines run in favor of the government. And this is an agonizing thing for people who go through this process. Again, you have this long investigation, what I call a due process deficient small window to mount your defense, followed by years awaiting a decision. And this leads to another, and let me give you some data, because I gave this data at the Fifth Circuit at the en banc stage. And honestly, I do not think any of the 16 judges I argued this in front of had any idea this kind of thing went on. Michelle Cochran was in that administrative maw for 6 years. Ray Lucia, 8 years. George Jarkisy, 7 years. Christopher Gibson, another client of mine, 5 years. David Bandemir, 10 years. And I honestly think the judges were shocked. The people could get caught up in such extended, costly, grueling proceedings for so long before they could ever get to what I call a real court of law. And even there, it's just the circuit court which has to defer to the administrative record, which is troublingly very government biased because of the deadlines and the ability to prepare your case. Again, why wasn't I aware that this was going on? And also, and we've actually known in the Cochran case, which raised similar defect in administrative law judges to that of Mr. Lucia, only it had to do with the unconstitutional multiple layers of removal protections. We've known since 2010 that the rule of decision, both on jurisdiction of a district court to entertain a removal challenge and the merits, which is that you cannot have more than one layer of removal protection, was decided in 2010. And yet there I am in 2021 arguing to a court 12 years later, plowing the very same ground that had already been decided at the Supreme Court over a decade earlier. Again, how long has this been going on? And to me, one of the most interesting things that came out at Michelle Cochran's argument was Justice Alito saying, maybe I'm being simplistic here, but doesn't Free Enterprise Fund decide this case? And Paul Clement, a very seasoned, skilled practitioner of appellate law, said, well, I don't know, Your Honor, whether I'd say simplistic. How about straightforward? And then they back and forth, and then they landed on textual under the statute, which had been Michelle's argument, my client's Cochran's argument, and to which Paul Clement said, well, you're really going to like the Cochran argument that's about to be made, because the two cases were argued back to back. Again, why are we still arguing these things when the precedent has been set in 2010 on this? And the 34 Act section, which provides for administrative proceedings, has nothing in it whatsoever that strips jurisdiction from the district courts. And a simple reading of the text of the statute would tell you that. See, we had three things in our favor. The textual argument under the statute, because there are, for example, in the FDIC, they do strip jurisdiction from the district courts, and the Supreme Court law does allow Congress to do that, but it has to do so very clearly. Otherwise, the presumption is supposed to be in favor of district court jurisdiction for constitutional questions. So we had our statutory argument. We had a slam dunk with Free Enterprise Fund, which several of the justices at argument admitted decided the case. And best of all, we had a logical argument. Justice Scalia once said, if you've got logic on your side, it's better than doctrine, it's better than case law. You've got a winner. And the reason this is a winner is otherwise you have people like Michelle Cochran going through, as in her case, 6 years, and if she wins at the circuit court, her prize, just like Mr. Lucia, is they have to go back and do it all over again. In Mr. Lucia's case, the Supreme Court sent him back send him back on remand, and then the SEC put him before another administrative law judge. And at that point, my organization, New Civil Liberties Alliance, started to represent Mr. Lucia. We objected to his having to go through a second unconstitutional administrative law proceeding where the judge enjoyed too many layers of removal protections. District court tossed us out. I briefed it at the night, and Mr. Lucia, by that point, had long since been broke, but simply couldn't deal with the publicity. The SEC was harassing his son, and so he settled. And this is something that the SEC counts on. 98% of their cases settle. So, again, why do we not know about these things? Well, let me tell you a little bit about what I would call other scandals. We first had the scandal that the appointments problem was hidden. And I'm going to ask you on this one to do a thought experiment. Imagine you travel to some foreign country where you're going to live, and you learn that in that country, thousands of people can be charged by powerful government agencies each year, and defending yourself will take in excess of $1 million to defend yourself. But good news, you can settle. If you are willing to hand over your free speech rights in the process. And this, my friend, is what is known as the SEC gag rule. In 1972, the SEC deceitfully slipped into the Federal Register a rule that imposes a non-negotiable condition on anyone who wishes to enter into a settlement agreement with the agency. They are prohibited from making any public statement that questions any allegation the SEC has made against them, or that even creates the impression that they were not guilty of any and everything the SEC charged them with. That rule was published without notice and comment, slipped into the Federal Register, and made effective immediately. There are only two agencies in the federal government that do this. In 1998, the SEC rule dates back to 1972, but the CFTC in 1998, I'm imagining, said, ooh, that's cool, we want one of those. So did the same darn thing. They published it without notice and comment, effective immediately. And bingo, they get to silence 98% of the people who settle with it. I think that gag rule might be why we don't know about all these people who are sucked into the administrative law proceedings, because they can't talk about them. Now, just a minute. Another scandal. Cochran and Jarkissi are two cases in the Fifth Circuit in which I represented Michelle Cochran, and Mr. Jarkissi was represented by other counsel in Texas. And Mr. Jarkissi's case is pending at the Fifth Circuit at this point, and the SEC has petitioned for cert to set aside our victory, 9-7 victory, that you got to go into district court to challenge this. And the SEC's bugging me. They're saying, agree to a stay of your administrative proceedings, agree to a stay of your district court proceedings. And I said, but I got to stay. Nothing's happening on either one of the cases, and we're probably headed up to the Supreme Court. I don't want to waste time or resources on this. But they said, no, it's important that we have a formal stay. So I signed a joint motion for stay. Boom! 2 hours later on my ECF comes across on the computer that the SEC is disclosing they have had a control deficiency. Now, control deficiency is sort of Orwellian sounding, and what it means is that the enforcement staff had been accessing the administrative law judge's files. That's exactly what people like me and Philip Hamburger and people fighting the administrative state are concerned about. When your judge is employed by your prosecutor, there should be some sort of division and line, and they always say there is. But here they had to disclose in a filing at the Supreme Court, just as we were about to go into arguing this, that in both Mr. Jarkissi's and Michelle Cochran's case, there had been sharing of files, and furthermore, they say this also happened in some other cases, but we are only really talking about these two. Shocking. Okay. So I asked you to do a little thought experiment with me, to go to a foreign country that had this gag rule, and I would ask you, if you heard about that, just in the abstract, would you think you were in the United States of America? That they could gag you if you settled with them? I wouldn't. I sure didn't. So in 2018, when I started this job, and this was long before Mr. Romerl and Mr. Lucia had his post-Supreme Court proceedings, I published an editorial in this Wall Street Journal called "How the SEC Silences Criticism." That got 20 favorable comments. You can still go online and find them, and pretty much the theme of the 20 favorable comments was, why didn't we know about this? Why doesn't anybody know about this? I had no idea. What's the government doing here, right? But there was one critical comment. I'm going to read it to you. This commenter says, these 20 comments and the original op-ed piece ignores an important condition precedent to the SEC's so-called gag rule, to wit, persons accused of illegal conduct must first agree to forego their right to deny their alleged misconduct in return for being able to settle the SEC's claims. If companies and individuals want to contest SEC charges, they can and often do litigate. Those who litigate can deny the SEC's allegations to their heart's content if they prevail. Indeed, they can deny the SEC charges even if they are found to have acted improperly. But, says this commenter, the essence of every privilege is that individuals and companies can waive them if they knowingly do so. There's no reason why they cannot waive their First Amendment rights if they choose to do so. So this is going to be my first game, fun guess. Anybody want to know who was trolling me, making that comment? And if you're really swift, you can probably hop on your phone and look at comment 3, because it's still up there. My troll was former SEC Chairman Harvey Pitt. And Mr. Pitt demonstrated with that snarky comment that he does not know the difference between a right and a privilege. He called your First Amendment speech rights a privilege, which you could just give away. And I would like to tell you that's an outlier in agency attitude, but I would be wrong. And in fact, I have litigated cases on the gag rule in the Second Circuit and in the Fifth Circuit, and am making progress, and I'll talk to you more about that later. But so far, the courts are upholding it because they view it as something you agreed to do. So again, we're digging to figure out why don't we know about all these agency adjudications and what people go through, and the reason is nobody can talk about it. 98% of the people are silenced for life. Now, the other thing is that the gag imposes a permanent reputational and occupational death sentence on you. Let me explain how this works. When the SEC charges you, they are famous for their inflammatory press releases, which take the worst view of everything you did, heaps upon allegations of misconduct. And if you later settle and are gagged, that's all the world will know about you and the SEC. The government gets the last and the only word about you. Ray Lucia couldn't get a job as a school teacher because the background checks would show his SEC enforcement action. And by the way, that reputational and occupational damage is really from the time they charge you, because that's easy to find and very searchable. So again, not only does this hide agency enforcement facts, it permanently tars the reputation of anyone charged by the SEC. Now, I told you I challenged this in the Second Circuit, and in a decision I could dissect for you, but I won't. I lost there, and the Second Circuit is famous for never sitting en banc, so I was not able to get an en banc rehearing. I was able to get Floyd Abrams to lead NCLA's petition for certiorari, and I think Mike and Todd in the back of the room probably know who Floyd Abrams is. Some of you younger people may not know, but he is the premier First Amendment lawyer in the country. And cert was denied because we didn't have a technical split on exactly this SEC rule, although we had a split definitely amongst other circuits, including the Ninth Circuit, which said that the government cannot impose a First Amendment ban, a restriction on your First Amendment rights as part of a settlement. In that case, it was by saying disparaging comments about a county commissioner. And then another person had settled in a different case and agreed to never run for public office again, and the federal courts held that was unconstitutional. So in our view, we had circuit splits. And also the Fourth Circuit had recently ruled, actually, while the case was going on, that in a police brutality settlement, the city of Baltimore could not impose a don't talk to the press condition of settlement on you, and that was unconstitutional. So we thought we had a lot of good circuit authority, but I am looking to create a split on that, and we had a case in the Fifth Circuit, and we lost on a technical thing that will just confuse and or bore you. But two judges on the panel, Judge Edith Jones and Kyle Duncan, said in a written concurrence, the SEC makes defendants agree to gag provisions, leaving them no choice but to stay silent or get bankrupted by having to continue litigating, said Judge Jones. A more effective prior restraint is hard to imagine. And then we had really recently a really cool development. Unknown to Floyd Abrams, with whom I was working very closely at the time, his daughter, who is a SDNY judge, Ronnie Abrams, decided to actually look at one of these consents presented to her upon settlement And she, sua sponte, so it wasn't the person being bound by the gag, she said she wanted a letter from the SEC to explain why it would be entitled to a gag of speech. The letter she received was unsatisfactory to her, and so she wrote a wonderful opinion. She had to follow the law of her circuit in the Second Circuit case that I had litigated, and she had to impose the gag. But she said, I will not do so silently. That's what's known as ruling dubitante, and it means a lower court judge, known that they're bound by a higher court's precedent, still say, as a judge that is sworn to uphold the Constitution, they will speak their mind. And it's a beautiful opinion. I highly recommend that you read it. What I hope is coming through here is a pattern of misconduct and deception. In Lucia, they were arguing that there was no appointment problem, even though no one knew better than the SEC that the judges weren't appointed. On the removal questions, we've known the answer to that since 2010. In Jarkissi and Cochran, you've got this control deficiency. For the gag rule, never published it violated the APA because it was not published with notice or comment. This is a pretty sorry state of affairs of agency power, just doing things without any check on it whatsoever. I think there are two other cases that were mentioned in the invitation, and I want to mention them because I think they're really important areas that will be receiving a lot of attention. And the first one is Gundy, and that's a case which had to do with registration of sex offenders. And what happened there was Congress couldn't figure out what to do with people who had been convicted of sex offenses before this law came into effect. They knew what they were going to require of going forward for people convicted of sex offenses, but what do you do with people with prior convictions? So, unable to reach an agreement about how to handle past sex offenders, they punted the lawmaking power to the Attorney General. That means that the Attorney General makes the rules and then prosecutes them. That is the very thing the founders separated the departments of government to protect. The other case I want to mention is West Virginia versus EPA. It's what's known and will probably get a lot of press on in terms of being a major questions case. I'm less convinced by the major questions rationale. I think, what do you do with people who have minor questions? Does it still mean that the agency can operate outside of its regulatory remit? I don't think it does. I think West Virginia is about one thing, and that is consent of the government. You may remember that the big question in West Virginia versus EPA turned on how do you define system? And system under the Clean Power Plan was a word that Justice Kagan in her dissent viewed as that is something where the EPA could look at, coal, natural gas, alternative agencies, wind and solar, and it could tell, okay, you here, coal plant in West Virginia, you close down or convert to natural gas, and say to another energy producer, well, you need to up your production, et cetera. That's a view. I like to think of that as, do any of you remember the Truman Show, where you have somebody sort of up there making these big magic decisions and moving all the things around? And the fact is, in 1973, when they were doing the various versions of the powers conferred upon the EPA, they were saying that you could say to coal power plants, well, you need to get a scrubber, or you need to produce your energy in a cleaner manner, but they couldn't shut you down or orchestrate nationally what kinds of plants produce power. Again, I don't think that was a hard case. But it was interesting to me that it turned on how do you define system. And so I was Googling, because I was writing an article about the case, and I found a fascinating article. It dates back to 2013, written by Kathleen Geyer in the Washington Monthly. And her proposition was, the article's, by the way, called "It's the System, Man." And I think Mike is probably old enough to remember that when that was the complaint of a lot of folks in the 1970s. And the burden of her argument, which was an important one, was that people were being too hard on President Obama for not just making everything he ran on happen. And she says in this article, many systemic aspects of our form of government make political change incredibly different. We lack a parliamentary system. Our courts and legal system enforce laws. We have a bicameral legislature, a committee system, and the Senate's filibuster. And these are all veto choke points for any piece of legislation. On top of that, there's the Electoral College and the Senate, which give disproportionate weight to conservative states and tilt the political playing field to the right. To have a significantly more democratic, less sclerotic government, we'd have to change each and every one of these features and institutions. And she closes with, unfortunately, that's not going to happen anytime soon. She's right. The Constitution was expressly designed to prevent the administrative state. We don't have a parliamentary system. We have committee systems, bicameral legislatures. We have a requirement that the president sign things into law. And the very thing she's bewailing is exactly, for some of us anyway, it's a feature, not a bug. So that's the West Virginia case and my views on this. But I think at this point, what I'd like to make a plea for is a little noticed body of law. And that is what I like to call the anti-we do it all the time body of law. The New Jersey Supreme Court put it this way. In a case like West Virginia versus EPA, which is a separation of powers case, the New Jersey Supreme Court in 1952 said, "We are not impressed by the plaintiff's argument that the practice of violating the separation of powers is longstanding, for if that is the practice, it should be terminated, not perpetuated." Joseph Story in 1833 and later Thomas Cooley in 1868 looked at it this way. Acquiescence for no length of time can legalize a clear usurpation of power where the people have plainly expressed their will in the Constitution. A power is frequently yielded to merely because it is claimed, and it may be exercised for a long period in violation of the constitutional prohibition without the mischief which the Constitution was designed to guard against appearing, or without anyone being sufficiently interested in the subject to raise the question. But these circumstances cannot be allowed to sanction a clear infraction of the Constitution. And you will find, if you look for the cases, they're all over state and federal courts, mostly of venerable age. The most recent one to say something like this was in the Cochran Fifth Circuit en banc opinion, mostly in the concurrence by Judge Oldham, which it did not get a majority. There's a majority opinion that's 9-7, and then Judge Oldham's concurrence got a lot of votes, but not the majority. And that en banc opinion is lively reading. It goes, let me say, I don't think Woodrow Wilson will ever recover from the treatment he received from that court. But it is a resurgence of that kind of thinking. It doesn't matter how long the constitutional violation has gone on, but if it should come to the attention of the courts, it needs to be remedied. The founders knew how fragile these constructs of their imagination were. Madison famously asked in Federalist Number 48, this is a quote, "Will it be sufficient to mark with precision the boundaries of these departments in the Constitution of the government, and to trust to these parchment barriers against the encroaching spirit of power?" Madison concluded, no. And as I hope I've been able to explicate to you tonight through the various cases, whether it be the longstanding ability of the SEC to have appointments-free judges rule in people's cases, or judges who have too many removal protections, or the various other what I think are shocking violations of whether it be the APA or the Constitution. We need courts to start rethinking how they look at these clearly unconstitutional proceedings. I think the cure for this, and it is an insidious revolution. We are governed by the administrative state in ways we don't recognize or understand. And I'll be the first to admit I underestimated it a great deal before I took on this job. And then I was always saying, wait, what? They could do that? I mean, I was probably walking around in a permanent state of shock for a good part of a year. I mean, for example, on the gag rule, only 2 agencies have this. Every other administrative agency, state or federal, seems to be able to robustly regulate Americans without resorting to gagging them about the process. I mean, it's astonishing to me that practice was ever initiated or perpetuated, and it does need to stop. I also think that the cure, I think, to all of this is found in the First Amendment. You have to call tyranny by its name. You have to expose the frightening constraints on speech that administrative power imposes, and go to the courts and ask them to exercise their powers robustly, with fortitude, and with judicial muscle. I'm at my time? Yeah, sorry.
Your thoughts, mind if I ask a question?
I love it. I'm sorry, I went over.
I get the constitutional theory and Lucia, and think that you and the court are right about it, but I don't really understand why it is a good thing for people actually litigating against the government, because as I understand it, the argument is that it was necessary to make it easier for these administrative judges to be fired. And how does that, I would just think that will make them even more likely to be yes men than they were before.
Yeah, that's a very cogent criticism, and I think the answer to this is I don't really think it matters whether it's 1, 2, 3, 4, or 5 layers of protection. They're employed by your prosecutor. That's who signs their paycheck. They go to work in the same building every day. And we have a number of stories. I told you about Cameron Elliott and the fact that he was bragging about how he always rules in favor of the agency and all that. He left the FCC shortly after Lucia. I'm going to speculate here that he was asked to leave because he was saying the quiet part out loud. So I don't think the numbers of layers of protection is the problem. It's taking adjudication out of the judicial branch and putting it into the executive branch that is a systemic, structural problem.
Hi. I'm going to follow up on that question on remedies. So somebody who has been very publicly and very effective confronting the SEC is Elon Musk. He doesn't care about the rulings. And the question is, why don't you take that approach? Like recruit billionaires who take on the SEC, or recruit, raise $1 billion to pay the settlement so you can criticize the SEC. So instead of going through the courts, be more, a PR campaign against them so everybody knows what they're doing.
Absolutely. And I'm glad you asked that question, because in every one of our gag cases, and in Cochran as well, which is the removal case, Mark Cuban, Nelson Obus, and Philip Goldstein have filed amicus briefs in the cases. And then in our cert petition to the Supreme Court in the gag case out of the Second Circuit, Elon Musk joined them. So, yes, I admire their generosity, Mark Cuban's generosity, and Nelson Obus. And if you want a really interesting read about the problem, Google Nelson Obus in the Wall Street Journal, and he will tell you exactly how that administrative proceeding works And it's not a pretty story.
I'm hearing my friends in one political tribe listening to this and saying, see, that's what happens when the guys in this other political tribe get their way. But I didn't hear anything about variation over the decades from one kind of administration to another kind of administration. It sounds like this has been fairly even regardless who is in charge. Is that correct? Did I miss something?
Well, it kind of depends on the problem, because certainly West Virginia versus EPA is definitely a situation that will change depending on who's in power. And in fact, in that case, there was an issue of mootness. I happen to think the court made the right decision to hear the case, because otherwise you just flip-flop between administrations and you never get the question before Congress, and they're the only ones with the power to decide these claims. But in other things, like the gags, that was instituted under Nixon. It's not a political party thing at all. It has to do with exactly what Madison was talking about, the encroaching spirit of power. Once you have these very hidden agencies doing these hidden things that we don't even know about, the urge to abuse power is a very basic part of human nature, and you see it, whether it be in the Cameron Elliott's of the world. One of my favorite moments in the oral argument at the Fifth Circuit in the gag case was the SEC lawyers out there saying, yes, we can re-prosecute people if they speak in a way we don't like, but we don't really do that. And Judge Jones says, so you're bullying them, are you? And that's exactly the point. You should never have to surrender your First Amendment rights to settle with the government. It's unthinkable.
Maggie, can everybody hear me? Come down and speak in the microphone so there'll be the people listening to the tape. Oh, I see.
I'm Todd Henderson. I have a quick comment and then a question. The comment is to note the irony that the SEC noted conflicts of interest, a lot like these, in banks and investment banks, and has rigorously enforced various protections within firms. So JP Morgan's salespeople and their analysts have to sit on different floors, be paid in different ways. There's a very elaborate consent decree that addresses similar problems within banks enforced by the SEC. And so they should just turn that lens on themselves at a minimum for these things. That's a comment. My question is, the other entity that's not part of your story but seems problematic, maybe even worse, is FINRA, who is the sort of private regulator of a lot of stockbrokers and stock professionals. They're unconstrained by the Constitution because it's a private entity. But unlike the bar exam, which can disbar people, FINRA is actively throwing people out of the securities industry for things like backtesting all the time. They have a broker sort of reputation software system that denies people employment opportunities and takes their livelihoods away constantly. They're very much in bed with the SEC. And best I can tell, they're the government, but just under a different brand. And so do you have any plans to challenge them, or how do you think about what that litigation might look like in light of the fact that they're not a governmental entity?
Well, I'm so glad you asked that question, because the way we look at that problem is you have the government working through a private entity doing things the government itself cannot do. The biggest case we have on that right now is in a case first started by us in Ohio, where we understood that the government was taking COVID misinformation people and asking Twitter to shut them down. And then later in a case called Missouri versus Biden, where NCLA is a party, we discovered a very widespread abuse of that power. And the government knows it can't shut down your Twitter account, but it can lean on Twitter and in very direct ways and make them do that. So the problem of the government exercising its muscle over private entities is a huge problem, and yes, we are looking at FINRA. As to your comment about the irony or perhaps hypocrisy, I might go that far. You remember the control deficiency? Well, in the filing they made in Cochran at the Supreme Court, they say, "Oh, yes, this is, a problem. We're sorry, but we hired an outside independent group to research this, and they concluded there was no problem." Okay. Well, first of all, the law requires them to go to the Inspector General. They did not. Second of all, the group they hired is called Berkeley Research Group, a firm that does millions of dollars of business with the SEC by serving as their expert in litigation. And their conclusion that nothing went awry is pretty much foregone, and I would just simply add, what do you think the SEC would do to a private company that wallpapered its own conflicts of interest in that fashion? And the answer is it would not be pretty.
Thank you. I had a question. It was actually kind of similar to Michael's, where it felt like some of the symptoms you were describing, there was a disconnect between those symptoms, like they're backlogged, you spend 6 years, you don't have a lot of due process, and then the cause that you assigned it is that, insulation from removal. And then your response was, well, it's just adjudication shouldn't happen in the executive branch. And so I guess I'm curious what you would propose instead. Would you rather Mr. Lucia get no process before they impose a sanction?
Oh, no.
Or should they just all go to the courts, which are already quite backlogged?
Just hire more district judges.
Okay, so just a lot.
There's only
more
5 judges at
courts?
the SEC, 1 judge at the FTC. It's not hard to hire. People are dying to become district court judges. A very easy fix.
Okay. And you also, I know in your talk you didn't end up talking about Chevron, but you talked about it in the beginning, and so I was wondering if you could talk at all. You seem to think that also is bad, and I guess I'd love it if you could elaborate on that, why that is. As I see it, it only would come into play in the case where you decide that legislation is ambiguous. Mm-hmm. So if it's clear, we aren't even there. Mm-hmm. And whenever something's ambiguous, you sort of have a choice between 2 errors. You might accidentally hold that they don't have that power, but they actually did, mm-hmm. or the opposite.
Right.
And I guess, why would we, in the case where they have been exercising the power, and now all of a sudden we tell them, never mind, that's not within your power. I think there's circumstantial reasons to think that error would be less common because Congress could have already spoken up if that was an incorrect use of the delegation. Whereas in the other case, you're definitely forcing it back in Congress's camp to repass the delegation. If that is what you meant, say it again. And so I guess I'm wondering, why are you so certain that type of error is a worse error to make?
Because it favors one party. Judges take an oath of office that they will rule without favor or preference between 2 parties, and when one of them is wearing a government sign on their chest, they defer to them, and that's just wrong. It is. And I will tell you from my 40-some years of litigation, the government already gets a huge break. I mean, if you've ever gone into court against an attorney general or against, it's right there, the judges perking up and listening to them more. You certainly don't need a doctrine that then says this is a good idea. The government's very powerful.
Hi, thanks for your talk. I apologize if this question is somehow simplistic. I'm just trying to clarify my own grasp of the sort of not an issue. So identifying the First Amendment harms seems clear. What I'm wondering about is what harms you could then allege upon enforcement of the gag rule, because enforcement seems to be A, rare, and then B, would vacate the settlement and litigate, subsequently restoring the right of speech that's being denied by the rule. And so the question of harms seems complex, because you then need to deny the ability of the agency to enforce a, theoretically, legitimate breach of policy or law. So what's the sort of injunctive relief the court could then deliver to say, you can't settle or you can't enforce?
You can't gag. okay? Every other agency in the world, settles with people, and you pay money, and they can walk away and say what they want. And and it's very easy to fix this problem. The SEC is famous for its press releases. So say Elon Musk settles with them and then goes and says, well, they're full of baloney. The SEC can come back with its own press release, more speech, which is always the cure for First Amendment, and say Elon Musk is, a dangerous risk taker and is loose with the truth, and fight it out in the press, but don't gag him.
I see our time is now up. It's gone very quickly. Please join me in thanking Peggy Little for that interesting talk.